Good afternoon, everyone. Thank you so much for joining us today for CEI's Hill briefing on the de-weaponization of finance. For those unfamiliar with CEI, the Competitive Enterprise Institute is a DC-based think tank that primarily focuses on domestic regulatory policy issues. We're also dedicated to advancing and defending the principles of limited government, free enterprise, and individual liberty. My name is Matthew Adams, and I'm the Government Affairs Manager at CEI. For those of you who registered for the event, you probably got many emails from me this week. And if you're a Hill staffer, you definitely get many emails from CEI Government Affairs. So I'm the man behind those emails you get each week. Before I hand it over to Richard Morrison from CEI, I did just want to say that if you're interested in partnering with CEI on any of the issues we talk about today, I'll be around after the event to chat with you. I'm happy to exchange contact information. And I did just want to flag that we have a very ambitious event series in the works for the 119th Congress, so be on the lookout for those. So without further ado, it is my honor to introduce Richard Morrison, a senior fellow at CEI, who will be leading today's event.
All right, thank you very much, Matt. So welcome, and again, thank you for everyone who made time to join us today for a discussion on what I think is a very important issue. So the title of today's event is De-Weaponization of Financial Regulation. That term is probably going to be familiar to a lot of you in this room, but some people might ask, what exactly do you mean by the term weaponization? So when Judiciary Chairman Jim Jordan created the Select Subcommittee on Weaponization of the Federal Government in 2023, he delivered a floor speech listing some of the problems that he was interested in confronting. So at the time, those included social media censorship of dissent over COVID policy. That's the kind that was recently reviewed by the Supreme Court in the case Murphy versus Missouri. It included government efforts to demonize parents who were coming forward with justified complaints at their local public school board meetings and being at times equated with domestic terrorists. And it included political targeting and selective prosecution of Americans whose expressed opinions at odds with administration policy. So all of these cases, and the ones we'll focus on today, specific ones, involve the government, usually at the federal level, using its powers outside of the due process of law enforcement to harm, attack, and persecute American citizens as individuals, and sometimes as business owners and employees. So most of Chairman Jordan's original examples had to do with the FBI or the White House operating at a very high level. And the threats we'll examine from the world of financial regulation today are more likely to come from the Department of the Treasury, the Office of the Comptroller of the Currency, the Federal Deposit Insurance Corporation, or the Securities and Exchange Commission. So they involve men and women with significant government power and discretion, targeting people and businesses for harassment because they simply don't like them or approve of their business dealings or their political speech. That kind of policy is thoroughly un-American and has no place in our constitutional order. As the Select Subcommittee's hearings have demonstrated, and this is no mere warning about a potential far-off dystopian future, these abuses have already happened, including long before the subcommittee's existence, repeatedly, going back in the case of, again, specifically financial regulation, at least 2 administrations, to the infamous case of the Obama-era Operation Choke Point, which you may be familiar with, which my colleague Iain Murray will shortly describe. It's happening now to cryptocurrency developers and investors in a process people are already calling Choke Point 2.0, as our panelist Eric Peterson described. And it could very easily be turbocharged in the future if Congress allows the Federal Reserve to create a central bank digital currency, as our final panelist Anthony will explain. We, at our best, live in a country, as John Adams famously said, of laws, not of men. When a citizen has committed no crime or injury against his fellow man, he should have nothing to fear from an honest and just government. Yet we're in the midst of a time when our ability to run a business or access financial services can become dependent on whether a Deputy Assistant Secretary of the Treasury personally likes what you do, or if he secretly hates your guts. If this was the country it should be, it wouldn't matter if some federal bureaucrat happens to like gun shops, or payday lenders, or precious metal dealers, or Dogecoin, or junk food, or oil drilling, or defense contractors. The only thing that should matter is if they and we are minding their own business and following the law, and on any given day, the vast majority of us are. Finally, there's plenty of levers of government, there's plenty of levels of government, and plenty of levers of influence which could end up being weaponized against the American public. We chose financial regulators as our focus today for two reasons. One, because we've already seen abuses in real life in the United States, and we have every reason to think they could occur again. But also because we know that interfering with an individual's or a business's ability to make and move and invest their own money isn't just about money. It's a way to cripple them and stop them from freely expressing their political and moral beliefs. Remember back in 2022 when Canadian truckers were protesting COVID policy and Prime Minister Justin Trudeau's government announced that they would be freezing their bank accounts and suspending their vehicle insurance, all without a court order or any finding of guilt. More than a few COVID officials in this country looked on with envy at the flexing of executive authority across the border. That is something we should be concerned about. And much more recently here, state officials here in the United States, state officials in New York were rebuked by the US Supreme Court just recently in the case of National Rifle Association versus Volo. In that case, the now former superintendent of New York's Department of Financial Services, Maria Volo, violated the First Amendment by coercing regulated entities to terminate their business relationship with the NRA in order to punish and suppress the NRA's Second Amendment advocacy. Now, just think about that. State officials violated one constitutional right in order to harass an organization dedicated to advancing another constitutional right, and it took a unanimous 9-0 Supreme Court opinion to get them to stop. And I think that should make us wonder how many other less prominent and less well-funded organizations suffered a similar fate in silence before the NRA was able to successfully take their case all the way to the Supreme Court. No small undertaking. So in order to get a better understanding of this threat from the past, present, and future, we have three distinguished panelists who come at it from three different angles. So our panelists are Iain Murray, who's Vice President of Strategy, a Senior Fellow, and my colleague at the Competitive Enterprise Institute. Eric Peterson is the Policy Director for the Satoshi Action Fund, formerly of the Pelican Institute in Louisiana and Americans for Prosperity. And Nick Anthony, to my right, is a policy analyst at the Cato Institute Center for Monetary and Financial Alternatives and the author of the recent book, Digital Currency or Digital Control, Decoding CBDC and the Future of Money. After each of our panelists has their say, we'll be excited to go to you all for questions. Iain?
Thank you, Richard, for that kind introduction. As Richard suggested, it falls to me to look at the ancient history of financial weaponization, which is appropriate because I am actually an ancient historian. I'm a classical liberal in a very real sense. But I think it's really instructive to look at what happened with Operation Choke Point. Operation Choke Point came to light in 2013 when, as so often in these cases, the canary in the coal mine of free speech, a porn star of all people noted that she'd been debanked, a lady by the name of Chanel Preston. And then other actors started revealing the same thing. Then there was a slew of payday lenders who revealed that they had had their bank accounts closed. And then firearms dealers started reporting the same thing. And this spread to many other industries, but there didn't seem to be anything particularly connecting, pornography, payday lending, firearms. What was going on? What connected these debankings? Well, banks, when they close your accounts in the United States, generally tell you why. And so, one business that had been shut down had this from the Bank of America. We reviewed the nature of your business in light of current regulatory trends affecting your industry. Another, with a regional bank, Hancock Bank, we are unable to effectively manage your accounts on a level consistent with the heightened security required by our regulators for money service businesses. And what became apparent from this, these letters about the regulatory trends was that this was actually the result of 2 years of regulatory planning. There had been increased regulatory pressure on banks beginning in 2011. Using a guidance document which is not a formal rulemaking and does not have to go through the same procedures. The FDIC, the Federal Deposit Insurance Corporation, issued a circular to banks about how they should manage risks. And in particular, it basically invented a new category of risk, of reputational risk. The risk to the bank for its reputation from dealing with certain forms of businesses. In 2012, one of the many task forces that the Obama administration set up decided to use this circular, use this guidance document, to go after what it termed were scams. But in fact, many of them were actually legal businesses, including payday lending and third-party payment processors. And it decided to do this by targeting banks and credit card networks under the basis of this issue of reputational risk. It then the Department of Justice then reinterpreted a law, FIRIA, the Financial Institutions Reform, Recovery and Enforcement Act, which was meant to stop, to issue subpoenas to stop fraud against banks, to issue subpoenas alleging that the banks were engaged in fraud by not managing their reputational risk properly. So a subpoena was issued to a Delaware bank. A Department of Justice lawyer who was involved in that subpoena then decided to propose to the Department of Justice that they should implement a strategy to attack, I quote, internet, telemarketing, mail, and other mass market fraud against consumers by choking off fraudsters' access to the banking system. And that's how this got to be known as Operation Choke Point. The attorney noted in his proposal that banks are sensitive to the risk of civil or criminal liability and regulatory action. For a bank, getting a subpoena under FIRIA is really expensive and really disruptive to its businesses. So if they knew that associating with a certain business, as those outlined in the FDIC circular, was going to risk a subpoena, then they started shutting down access. And the FDIC very helpfully used to have on its website a list of all these businesses that it was targeting. They included things like cable box descramblers and Ponzi schemes, but also firearms sales and payday loans, and things like credit repair services and pornography. And you'll notice that that mixes already illegal businesses like Ponzi schemes and cable box descramblers with legitimate businesses like credit repair and payday lending, and businesses that actually have a constitutionally guaranteed role, like firearms sales. So how did we fight back against Operation Choke Point? And the debanked businesses and individuals didn't have any recourse from their banks, and they didn't know what was going on behind the scenes. So they came to your bosses. They came to congressmen. They came to think tanks like those here. And both Congress and think tanks submitted FOIAs, and we were able to compile together reports. There was a report from the House Oversight Committee, a report from Competitive Enterprise Institute, and congressmen, particularly Blaine Luetkemeyer, marvelous congressman who was a former banking supervisor and knew what was going on, started to investigate the issue and started talking to the regulators. This led to a bunch of whistleblowers coming out who revealed exactly what was going on behind the scenes. And Congressman Luetkemeyer was able to get an apology from the head of the FDIC, who admitted that perhaps this wasn't actually the best way to go about regulating business. At the same time, the payday lenders had a court case, and when the Trump administration came in 2017, as soon as President Trump's people got in place, they started shutting down Operation Choke Point, and in 2019, the Department of Justice settled the payday lenders court case. Former Governor Frank Keating, who was the president of the American Bankers Association, summed up Operation Choke Point like this, and I think this is perfect. The clandestine Operation Choke Point had more in common with a purge of ideological foes than a regulatory enforcement action. It targeted wide swathes of businesses with little regard for whether legal businesses were swept up and harmed. In fact, that seemed to be the goal. So what lessons can we learn from Choke Point? A central one is that there's this chain of going from law to regulation to interpretation to use of that interpretation under discretion. And that chain allows for expansive redrawing of the original law's purpose. Hopefully, the Supreme Court's decisions in Volo and in Loper Bright that ended Chevron deference will make that chain of going from the law to your own discretion slightly more difficult. Banks need to be free to blame the regulators. Thankfully, they can do that here in the United States. In other countries where there are ways of debanking going on, the banks are actually forbidden from instructing their clients as to why they've been debanked. We're seeing that in my native UK at the moment. Oversight by elected representatives is absolutely essential. The work of Blaine Lukemeyer, Tom Emmer is very good on this sort of issue as well. The work by those representatives is essential. The trouble is that because the legal framework and incentives remain the same, the template for Operation Choke Point remains in place. And we're seeing it come back. When I talk about incentives, I mean financial institutions exist to provide value to customers and shareholders, and in so doing, they collect large amount of data. But the regulators have a right of access to this data. Under a court decision called Miller, there is no reasonable expectation of privacy in your financial data. The Bank Secrecy Act and other anti-money laundering and know your customer laws and regulations actually encourage the banks to send your data to the regulator. So banks are effectively deputized by law enforcement. And this has led to a sort of Stockholm syndrome among the banks. The regulatory pressures are all towards sharing information. And so we've now got to the stage where financial institutions are sharing information voluntarily rather than under threat of subpoena. So we saw, for instance, a Bank of America voluntarily shared information on its customers' whereabouts and activities in DC after January 6th. You know, the House Judiciary Committee put out a report in March this year which looked at more recent applications of Operation Choke Point-like activities. It revealed that law enforcement had asked banks to filter Zelle for the keywords Trump and MAGA and to monitor purchases of those well-known routes to radicalization, books. It concluded that there was a pattern of financial surveillance aimed at millions of Americans who hold conservative viewpoints or simply exercise their Second Amendment rights. FinCEN, the Financial Crimes Enforcement Network, has been a particular player in this revised version of Operation Choke Point. It has instructed financial institutions on how to use merchant category codes to search through transactions to detect potential extremists. The keywords that financial institutions have been instructed to look through include things like small arms purchases or purchases at recreational stores like Cabela's or Dick's Sporting Goods. So, as the House Judiciary report said, Americans doing nothing other than shopping or exercising their Second Amendment rights were being tracked by financial institutions and federal law enforcement. So what can we conclude from all of this? The first is that this is primarily a problem of regulation and regulators overstepping their bounds. Banks, unfortunately, see no upside because the law is all pointed one way in protecting their customers. So regulators need to be disciplined and held to their actual mission, perhaps with threats of criminal penalties. Oversight by elected officials, by your bosses, is absolutely essential. And Congress should consider amending the law, especially the Bank Secrecy Act and other Know Your Customers and anti-money laundering laws, to help reinforce the concept of financial privacy. It should also amend FIRIA to make it absolutely clear to regulators that they can't use it in the way they have been using. One thing I have not mentioned in this is what's happening with crypto in Operation Choke Point 2.0, and my colleague Eric will be very happy to tell you about that.
Yeah, so thank you so much. I think you really laid out how Operation Choke Point 1.0 worked, right? It's that there's no policy through Congress, it's all through regulation. The House actually dealt with the sort of regulation, the over-regulation of the crypto industry, not just a few weeks ago with the turning over of Staff Accounting Bulletin 121, which all that said is that, not from a law from Congress, that if banks custody crypto assets, that they would count against liabilities, essentially ensuring that they could not be in the crypto custody business. But I think we need to take a step back and realize how pervasive this is to the crypto industry. I'm sure everybody here remembers the downfall of Silicon Valley Bank. That was a bank that got underwater on its treasury bonds. But what really happened at the same time that so many people forgot or just wasn't reported on because of how quickly things were moving, at the same time, the Federal Deposit Insurance Corporation went to shut down Silvergate Bank. Silvergate Bank previously had banked about 85% of its balances were with the crypto industry. If you were in the crypto industry and you were being banked, chances are you were being banked at Silvergate Bank. Now, this bank was 100% solvent. We know it was 100% solvent because when the FDIC shut it down because of risk to the system, even though it was only a medium-sized bank, that all of their depositors got paid back 100%. So clearly, even though Silicon Valley Bank was underwater, Silvergate Bank just fine. Barney Frank was on the board of Signature Bank. Obviously, the Dodd-Frank Act knows a little bit something about bank and bank regulation. He took to the pages of the Wall Street Journal to say that his bank, which again was closed and 100% solvent, was closed down because they banked the crypto industry. Let's be very clear what we're talking about when we're talking about banking the crypto industry. We're not talking about holding crypto assets. We're not talking about trading crypto assets. We're talking literally just about opening bank accounts for people to move dollars onto exchanges or for businesses such as the Bitcoin mining industry, which I know a lot about, from being able to open bank accounts. For those of you who don't know what Bitcoin mining is, it's very similar to the data center industry. I've had conversations with some of these folks who have been debanked 10 times. They don't own Bitcoin. They don't touch Bitcoin. All they do are manage the facilities, and they have to go to try to get a bank account and say, we're in the data center business. We're not in the Bitcoin business because it's so toxic to these banks that they won't get touched. I think really when we take a look at this and on how this is allowed to happen, my group, Satoshi Action Fund, is a group that primarily works in state policy. And if you listen to what Iain said, what's happening is it's all from the federal government and federal banking regulators and federal officials. And I think the real thing that we need to look about is why have we given so much power in the banking industry, in our financial system, to the federal government? And that's actually a fairly new phenomenon. The United States has a dual banking system. We're the only developed country that has a dual banking system. For most of our nation's history, outside of not even having a Federal Reserve Bank, the states were the primary regulators for banks. In fact, any business or any bank right now can go to their state regulator. I live in Louisiana, could go and get a Louisiana state chartered bank. The problem is, in order to interact with the banking system, the worldwide banking system, you have to go through the Federal Reserve. They, in fact, own the payment rails for banks to be able to settle with each other. And with that comes the regulatory oversight that Iain was talking about. I think this is most well known in the state of Wyoming. Wyoming has been a great leader in the cryptocurrency industry for quite some time. And they've absolutely seen the problems that the crypto industry has dealt with and continues to deal with in the banking industry. So as far back as 2019, they established a new kind of bank called Special Purpose Depository Institutions, known as Speedy Banks. 4 banks have gone through this process and are now certified, chartered by the state of Wyoming. These banks were actually designed to get around one of the regulators that we talked about, the FDIC. How did they do this? Well, they're 100% reserve-backed banks. In fact, they have to be overcapitalized. That means for every dollar on deposit, they have either treasury bonds or liquid capital that is 104%. That means if there's a run on the bank and everybody shows up and says, I want my money right now, the bank can give it. That is by Wyoming law. So they do not need FDIC insurance. Without FDIC insurance, there's sort of no choke point that the FDIC can do on them. So what happened when these banks came out, got their charter, met all the Wyoming laws? Again, we have a dual banking system. Our Constitution says Wyoming can be the regulator. They went and applied to the Federal Reserve for a master account. Master account, again, is what lets them interact with the banking system. Well, the Federal Reserve says, the statute says that any bank that has federally chartered or state chartered shall receive a master account. The Federal Reserve said, actually, we're going to revise that. Again, not through an act of Congress, through regulatory oversight. And now there are 3 ways that we're going to judge whether or not a bank or other financial institution should have access to a master account. Well, if you're a federally regulated bank, you just get one, not a problem. The lowest one, we're going to really look at you and make sure that you don't get a Federal Reserve master account, happens to be if you're a state chartered bank and don't have FDIC insurance. And in fact, they have all been denied master accounts. Caitlin Long, who runs Custodia Bank, has been denied a master account. They're currently in a lawsuit over this right now. They had previously worked with the Kansas City Fed, which said they were going to get a master account. That is, working its way through the court system. All of the other banks do not have a master account. And to show you how pervasive that this problem is, there are a lot of banks, fintechs, other sort of financial institutions that actually don't have a master account. What do? They have something called a correspondent banking relationship, which is you have a bank that doesn't have a master account but wants to access the Fedwire. They will form an agreement with some institution that does have a Fedwire. They'll pay them a few basis points, and we'll use that to settle accounts. Very few banks, if any, are willing to form correspondent banking relationships with any of these speedy banks. Why? Well, the same reasons you're just talking about, regulatory pressure. Now, it's a great bank that you have here. It would be a shame if you had to undergo a lot of expensive audits or suffered reputational risks from dealing with these institutions that are in the very, very risky cryptocurrency industry. We hope you will reconsider your options of dealing, again, in a perfectly legal industry in the United States. So I think there's really 2 issues here that are important. One is, how does this happen? What's going on? What are the actual mechanisms in which that allows Operation Chokepoint to happen? I think 2 is to understand what are potential long-term durable solutions for it. Again, we talked about, it happened during the Obama administration, then the Trump administration came in, that it stopped, not overnight. Obviously, personnel is policy, and it takes some time to work through that. Former President Trump was at the Bitcoin conference and said he would end Operation Chokepoint 2.0, and I'll take him at his word that if we were to do that. But then in 2028, if we go back to another administration, who's to say that the same power is not going to be used on some other industry? Maybe it's not the crypto industry next time, but it's maybe the AI industry or some other emerging industry. And I think for that, where our focus is, because we're so state focused, is returning that regulatory power back to the state. Because we live in a dual banking system, we live in a country where we have these laboratories of innovation, that any bank that is registered under Louisiana, Texas, Wyoming, should have access to the same financial payment rails as the traditional industry, and we should not have centralized all that power in Washington, D.C. without really understanding what we were doing at the time.
All right, thank you, Eric. And now move on to our final panelist, Nick Anthony.
I love that I get to come onto this with the final word being we shouldn't have centralized all that power in Washington, D.C. I really could not have asked for a better segue. In fact, having Iain as well tell you the history of what's been happening in the financial system is so helpful as well, because usually those are two of the things I have to break down first before even explaining what CBDC means. So for those that have not seen it, central bank digital currency is something that has really spread across the world. If you have not seen all the places it's at, I highly recommend checking out hrf.org/CBDC tracker to see what's happening in each jurisdiction. But what this means in short is having the government take over the financial system to establish accounts for individuals to have a direct digital liability of the central bank. And I think it's so interesting to be talking about this after both Iain and Eric, because one of the themes that came up in what both of them said was that the discretion of agencies has allowed sweeping actions to take place without much oversight. And those sweeping actions will take place again in one form or another if there is not some sort of check put in place. And credit to the House for passing the CBDC Anti-Surveillance Act, because that is putting a check in place. That is putting a check to say that the authority to issue a central bank digital currency rests with Congress, not with agencies. I'm sure many of you have seen on this issue that the Federal Reserve has kind of stepped back a little bit and said, we will not do this without Congress blessing it, but that wasn't always the case. That's actually a pretty recent stance. The Federal Reserve originally said, well, okay, you know what, retail CBDC, us offering a direct account from the central bank right to you, that's probably illegal. That's probably not okay. So we can get around this if we do it as an intermediated account. We can set up this different form, which is a retail account with extra steps. And that really comes into exactly what we were seeing with Choke Point, was taking the powers at hand and using them for something they were not meant for at all. And this is deeply concerning, to have a government have a direct relationship with citizens' finances. I hope all of you are regularly checking your credit and debit card statements and your, if you have PayPal, Venmo, or anything else. But something I want you to do either tonight or this weekend is to look through those statements and set aside the numbers. What do those statements say about you? What do those transactions say about who you are as individuals? Does it show where you get gas on your way to work? Does it show who you're paying your either rent or mortgage to? Does it say what books you buy or what hobbies you have? Maybe where you go to eat, where you celebrate a religion of your choice, or maybe even just what relationships you have. Our financial statements reveal so much about us. And that's why it's so concerning to put it in a position where a government has that connection to us, has that unfettered ability to step into our lives. Because like how the Department of Justice saw the existing financial system as an opportunity to, I think the exact quote was, to choke off these businesses from the air they need to survive, a CBDC would make that much worse. In fact, across the board, whether it's financial surveillance, financial control, the stability of the financial system writ large, the emergence of new innovations like cryptocurrency, there are problems today. Across the board, there are problems. But a CBDC would be almost the capstone in these problems. It would entrench issues that should have been corrected long ago. And it would be the probably worst thing that's happened just on privacy alone since the creation of both the Bank Secrecy Act and the third-party doctrine. So that's why it's something that I've written about in this book, because like how Iain said, originally, it took one person to speak out about getting debanked, and then other people started to speak out. And then it took organizations getting involved and Freedom of Information Act requests. It took years of research to find out what was actually happening. The same risk can happen here. If agencies have the discretion to move forward on their own, then it could be years before we reverse that tide, years before we push back and say, wait, no, they shouldn't have done this. So it's something that, while it's in the weeds of monetary and financial policy, it's something that we really need to consider now, because if we're doing it after the fact, it's going to be a much bigger burden to deal with.